to your mind, is it? I mean, 60 days.
On the money.
You've noticed recently that your parents seem to have aged quite rapidly, maybe with hearing loss, mobility issues, more trips to the doctors, and maybe you've tried to softly raise things like hearing aids, and maybe you need some help with the house cleaning, but they don't seem to want a bar of it. Don't worry, I'll call you if I need help. Well, they won't. Why should you do something now rather than put it off? This is all part of the ageing parent trap, which you will find out about this morning. 1300 222 774 if you've got some questions, or 0437 774 774, because we have Brian Hurd, a lawyer specialising in elders law and author of Avoiding the Ageing Parent Trap with you. Hello, Brian.
Good morning, Lisa.
And Rachel Lane from Aged Care Gurus, a financial advisor. Good morning, Rachel.
Thank you, Lisa.
So anything we share today is general in nature. It doesn't take into account your personal circumstances, financial situation or needs, but let's get cracking. Brian, you've written in your book that the biggest factor impacting happiness in later life, not health, not marriage, or even the question, do I have enough to live on in retirement? The biggest factor is your parents. Brian, why is this?
Well, I've been doing elder law for some 20 years, and what I've noticed is that longevity has a problem to confront, and that is the longer you live, the more frail you become. It's called frailty creep. Most of our adult children, of course, subconsciously know that, but fail to confront it. And there's no doubt that later life for our parents, and I add another dimension called parents-in-law, is a complex, dynamic family, financial and legal circumstance. And the result of not confronting it, particularly by the adult children, is they wait and they watch, and they have this subconscious fear about something happening, and then one day it happens. Today's the day, as they say. And you get a message from the hospital to say, Mum's in hospital, they've done everything they can for her, they can't do anything more, she has to leave, and she can't go home. That's called crisis management. And so many families enter into that crisis management stage because they've never planned or confronted what is almost inevitable. So they become frantic, they flail, and then ultimately the family fails. We have a failed family because they failed to confront it.
And in fact, you say that one of the big hurdles is family factions, and one of the biggest rifts can actually happen between siblings, even though you might have got along with your sibling before, particularly if one sibling has stepped into a bit of a martyr role. What happens here?
Well, the trouble is this puts a lot of pressure on the siblings in terms of coming together to try and work together in a sort of coalition to act in the best interests of their parents. Now, that is complicated in many cases because of repressed enmities and jealousies between children. They're spread all over the world, and you're left with one child who happens, unfortunately, to be located near the parents, and that's what you call the martyr child. So they become the point of contact and the point of tension and stress. That can lead, as you might appreciate, to all sorts of adverse consequences, particularly for the martyr child, and particularly if they are the decision maker for their parents. So suddenly they're descended upon by all the other siblings from all over the place, saying, what's happening? What are you doing? Why are you doing that? So it leads to all this tension that, again, would not have happened if they'd all confronted this before the event occurred. Having to confront it after it means they have to literally frantically find ways of communicating with each other, trusting each other, and then making the right decisions where appropriate for their parents.
And just sort of taking this to the nth degree, what happens when those early conversations haven't happened? What happens between the martyr role and the estranged other sibling?
It totally breaks down. They don't gather at Christmas anymore. And what's really insidious is that the breakdown of this relationship clearly adversely impacts on the parents, but also filters down to the children, the nieces and nephews. So it infects the lower level relationships within the extended family as well. So the whole family unit gets destroyed or imploded by the effect of this breakdown of relationships. It's really, really sad.
We're looking at the ageing parent trap. We've got Rachel Lane from Aged Care Gurus and Brian Hurd, a lawyer specialising in elders law. We're taking your questions, 1300 222 774 or 0437 774 774. Talk us through the enduring power of attorney and what this document is and how it can be used or misused, Brian.
Yes. Again, a lot of people don't have this document in place. A lot of people do what most Australians like to do about confronting the future. They do nothing. So it's very important to understand at the outset, if you do not have an enduring power of attorney in place, nobody can make financial decisions for you if you lose your capacity. So if your parents don't have an enduring power of attorney in place and they lose their capacity to make financial decisions, nobody in the entire world can make financial decisions for them, not even each other. So to have an enduring power of attorney in place is absolutely crucial because it facilitates, where it becomes necessary, decision-making. I've seen a case, for example, where a matriarch of a very large family in a very large business failed to have an enduring power of attorney in place and had 4 children, 3 of whom were lawyers, and the 4th one was a social worker. She never made an enduring power of attorney. She loses her capacity from a stroke. Nobody can make decisions for her or the company, so they have to go off to a tribunal. Now, they all went off in competition with each other, and as a result, none of them were appointed, and the disaster was imploded by the fact that the legal costs were over $400,000. Having an enduring power of attorney in place is absolutely crucial because it's a document where you appoint someone to make decisions for you if you lose your capacity to do so. And longevity means many of us will lose our capacity to make decisions. That's a fact. It's the effect of longevity. So this instrument, this document, it sounds pretty innocuous, but it can be absolutely vital if it's needed to be called upon in later life. It's a way of facilitating and maintaining good relationships because it creates a legal power in people to make decisions where that power would not exist if the enduring power of attorney didn't exist. Absolutely crucial, Lisa. I'm sure you have one in place, and your parents.
Yes, my parents do have an enduring power of attorney.
Excellent.
I'm wondering whether I do. I'll look into that. They're all more organised than I am. But Catherine is here with a question on 1300 222 774. Hello, Catherine.
Hello. Yes, I have a question about the difference between an enduring power of attorney and a general power of attorney. Reason for asking is that I approached Services Australia with a general power of attorney on behalf of my mother, and they declined to accept it because it was not an enduring power of attorney. My understanding is that a general power of attorney can be in place even when the person has capacity. An enduring power of attorney doesn't get invoked until the person lacks capacity. Is that correct?
This is an answer I hate giving as a lawyer, but the answer I have to say, it depends. A general power of attorney is enforceable where you appoint someone to make usually financial decisions for you. Yeah. But that general power of attorney comes to an end if the person who gave the power to you loses their capacity.
Loses capacity, yeah. Yeah.
So then they introduced the enduring power of attorney, which is a power of attorney that has the word enduring in front of it. And what that means is the power of attorney continues, it endures after you lose your capacity. Right. So unless you're in business where general powers of attorney are broadly used, for an individual, you really should have an enduring power of attorney. The power of attorney, the general power of attorney creates this problem, Catherine, that you've got. In other words, it creates doubt in the minds of Centrelink as to whether you can use it, even though technically, without seeing it, it probably can be used by you if your mum has capacity.
Yes.
But I would suggest your mum needs to have an enduring power of attorney to replace the general.
She has both. She has both.
Oh.
She has both. She has an enduring power of attorney and she has a general power of attorney. And the problem was that I took the general power of attorney to Services Australia so that I could get access to her Medicare records. She's interstate. I don't have a great relationship with her GP, and I was trying to find out if she'd been vaccinated against COVID.
Oh, right. Well, again, it depends on what the wording is of the enduring power of attorney. But in Queensland, for example, the enduring power of attorney can commence immediately in relation to her financial affairs without having to prove she's lost capacity. However, in relation to her personal health care, your power as her enduring power of attorney would not commence unless she has lost her capacity. So is there any reason, Catherine, why your mum can't ask for this information?
Yes, she has an appalling memory. She's 91. She has no access to a computer, and she doesn't have the patience to sit on the phone and press this number and press that number and press the other number.
Right. Okay. Well, I'd be pressing her GP if I was you. and explaining the problem and the circumstance. And hopefully the GP would see his or her way clear to facilitate your job, which is to manage your mum's affairs appropriately. That's the purpose of what you're doing. So most GPs would be compliant in that situation. They'd probably ring your mum and say, do you mind if I give this information or do this for your daughter? But be that as it may, they need to be more cooperative. They need to be able to assist you to obtain relatively important information for you to manage your mum's affairs.
Thank you so much, Catherine, for your call on 1300 222 774. We are talking about the ageing parent trap. And Brian Hurd is a lawyer specialising in elders law. We have Rachel Lane from Aged Care Gurus also in the studio. And Roz has called through. G'day, Roz.
Yes, good morning.
Good morning.
Thanks for taking my call. I have a 90-year-old mother, and she's quite lucid, and she's quite financially well off, let's say. And she's talking about giving money away, distributing money to family members. And I'm suggesting to her that I think it's good that she holds on to it, because if she needs to move into aged care, she's going to need it. Well, what do you think?
Roz, thank you. A great question there. We might go to Rachel from Aged Care Gurus to kick us off. Rachel?
Look, I agree with you, Roz. It's there's a number of issues around gifting, but the biggest issue that I'm sure Brian will agree with is that you lose control over the money. So sometimes people think, well, I'm going to gift this money to my family, but if I ever really need it back, they'll give it back to me. And sometimes it's spent on things like houses, boats, cars, that just you can't get that money back. But gifting money can also have some pretty nasty consequences when it comes to your pension and also your aged care costs. So any gift in excess of $10,000 per financial year or $30,000 in a 5-year period is what Centrelink will call a deprived asset. And they'll hold that just like it's sitting in your mum's bank account for 5 years and count it against her as an asset, but they'll also deem it to earn income. So, look, sometimes people undertake gifting strategies as part of a very long-term strategy because they know that for 5 years there's no benefit. But generally speaking, if you're thinking about possibly moving into aged care in the next 5 years, it's typically not a very good strategy, and it can lead to other knock-on effects, i.e. you need to sell the house to get access to the capital to pay for aged care because you've given away the investments outside the house, things like that.
And Brian, you have a lot of experience with dodgy sort of things that happen with gifting or things that might seem to be loans but they're actually gifts. What can you add to Roz's experience here?
Well, look, my answer to Roz's question is tell your mum don't. The reality is, as Rachel has said, it could particularly adversely affect her future when it comes to aged care, for example. But also it has technical legal consequences in the sense that it may impact on her will. Because if her will has been done on the assumption she has a certain estate, but she doesn't change her will after she gives away things, that could have a really bad consequence on the people she meant to benefit under her will if she doesn't change her will. So to that extent, there is a downstream legal consequence you need to take into account as well. Not to mention also that where you give money away to your enduring power of attorney, if one of them happens to be, for example, your enduring power of attorney, that's what's called a conflict transaction. So the reality is that creates an issue too when you give away money to someone who is your enduring power of attorney, such as a son or a daughter, in terms of creating that conflict of interest transaction. So it comes with all sorts of strings and complexities that sound simple, but generally speaking, my advice to anyone considering to do it is don't. There was a woman in Western Australia, I think a few years ago, who won $100,000 in lotto. She was on the pension and she gave it away to charity, thinking what a nice person she is and what a good cause it was, only to find out later she loses her pension because she gave it away. So the reality is, when you are ignorant of the consequences of a decision, that's when you make the worst decisions. Before you make a decision to gift things, for example, find out what the implications are. And then, if you still want to do it, do it. But if you don't and think it's not wise, don't.
Let's go to the phones. Rachel, I think let's just deal with this issue, though, that Brian raises of before you do anything, get some advice or at least understand the implications. I just want to talk about the implications of selling off your parents' house and what that has done in a financial sense. Rachel?
Yeah, sure. So A lot of people believe that they have to sell the family home to fund aged care, and it's simply not true. I even had someone write to me last week and say, won't the government force me to sell my mum's house? Won't the aged care facility force me to sell my mum's house? It's completely up to you. The reason people feel that pressure is because the price that is quoted for aged care beds is normally the lump sum price. So they'll say, this bed has a RAD, a refundable accommodation deposit, of $500,000. And people jump to this, I guess, fairly logical conclusion: we must pay $500,000 as a lump sum. But you don't have to. You can choose to pay it as a daily payment, and you can choose to pay it a bit of each, a bit of lump sum and a bit of daily payment. The issue with selling the family home is that you're realising an asset that would otherwise be capped at $197,735 for aged care means testing. So you're potentially liquidating something that's worth $1 million or $2 million more than that, possibly even more. The other thing is that from a pension point of view, that family home is exempt for 2 years from the day the mum moved out or the last of the spouse, if there was still a spouse in the home. So you're foregoing all of those special rules that only apply to the family home by liquidating that asset, so potentially causing, in some cases, complete loss of pension and potentially driving the cost of aged care up by tens of thousands of dollars a year.
Thank you, Rachel. On ABC Radio, you're listening to Lisa Leong, and we're avoiding the ageing parent trap with Rachel Lane, aged care gurus, and Brian Hurd, a lawyer specialising in elders law. We are taking your calls. Marianne, good morning.
Good morning.
We were talking about enduring powers of attorney, and you have something to clarify?
Mainly because I'm a GP, and I heard the lady who rang up before with understandable frustration in her voice when she was trying to get information possibly from the GP about her mother's vaccination status. And as a GP, I am very cognizant of the frustration that some of the relatives feel when they ring and say, I've got mum's power of attorney and I need to know X, Y, Z. Now, if mum still has capacity and I see her regularly, then I'm not giving any information, and this may be legally wrong, but as a GP, I'm not giving any information to anyone else unless mum gives me her permission. So, because there are plenty of reasons. I've got people ring up and saying, I need to find out whether she's got this health condition, and mum may actually not want you to know that she's got that health condition. So I guess we're in a difficult position, but ultimately, if the person still has capacity, it is their rights that I will be upholding. And if they give me permission to talk to you, I will talk to you. But I want that permission given to me first.
Thank you, Marianne. Calling through on 1300 222 774. Brian Hurd, as a lawyer specialising in elders law and very experienced with the machinations of families, you also talk about, children who are stepping in with seemingly with their parents' best interests at heart, but sometimes becoming quite dominating with decision making. Do you want to talk about that, and particularly the insight of Marianne, a GP who, is maybe feeling that people are demanding information that is not theirs?
Yes. Look, Marianne is technically correct in the sense that she has an obligation of confidentiality towards her patient. The first question, however, in response to a request from a daughter, say, for information about her health, would be, does the patient have capacity? Now, presumably Marianne is best placed to determine that. If she determines that the patient does not have capacity, and if the daughter does have a valid enduring power of attorney, then she's entitled to give that information to the enduring power of attorney with the daughter. If, however, Marianne takes the view that her patient does have capacity, then she's right. The enduring power of attorney is not entitled as of right to that information, but is if the patient gives the authority to Marianne to give that information. In relation to children who are dominating, the dominatrixes of the world, we see this a lot where, for some reason, and I still grapple with understanding why these children do what they do and how they think, children in family who tend to isolate their parents from the world generally, and particularly from other siblings. We also see these types of adult children who also want to control their parents' lives right down to their emotional lives. So we see, for example, quite often in aged care, an enduring power of attorney who happens to be a daughter give a direction to the aged care facility that their mum or dad is not to have any contact with another resident. Because what this daughter perceives is happening is that mum is sliding into a relationship with this other resident in the facility. So the daughter wants to effectively put a stop to that and direct the aged care facility to stop them having any contact with each other. Now, that's a bit of a conundrum for the facility because in reality, their job is to make sure that they provide the best care, and that includes, for example, relationship care for their residents. And they've got someone saying outside of the facility who happens to be purportedly legally entitled to say it, stop their contact. Now, that is, you would be surprised how common that is. And the reason for it is a technical reason, and that is the daughter doesn't want to see her mum sliding into some form of de facto relationship within the residential facility. On the other hand, of course, mum has a right to pursue the life she wants to, even if she has doubt or they have doubts about her capacity. It's all about her happiness, not about the legal implications for the children so far as their future entitlements are concerned. So this is a regrettable feature of many siblings in relationships with parents and their other siblings. And it's simply, I think, in many cases, motivated by that desire to preserve their future inheritance entitlements.
Now, David has called through on 1300 222 774, and we do have Brian Hurd, a lawyer specialising in elders law, and Rachel Lane, financial expert from Aged Care Gurus, who can answer your questions. Hello, David.
Yes, hello.
Hello. Can you explain your situation and your question?
Yeah, I've been listening to what's being said this morning, and a lot of it has a lot of what has been said has a lot of relevance to my situation, with a bit of a twist. Currently, my father's heading towards 90. Him and I have had a chat about the current will situation. At the present moment in time, it's 50-50 left to both myself and my brother. My brother has a young family. My brother's 57. He also has just been diagnosed with Alzheimer's and Parkinson's disease. The medical people say he's probably got anywhere between 4 and 6 years, and then I'm probably going to have to put him in the home. So, keeping that in mind, I've had a chat with my elderly father, and I have suggested to him, with regard to the enduring power of attorney, should be handed over to myself because it's not a control freak thing. It's the fact that my brother in 5 to 8 years won't be able to make the decisions that he needs to make for the rest of his family. And I tend to think his family will be jumping on board to make the decisions for him. So my situation is I would rather have, for want of a better term, the power of attorney to make those decisions for my brother.
And do you have a specific question, David?
I am uncertain of the direction I need to take.
With the enduring power of attorney?
Indeed.
Okay.
And it's to do with the best interests of my brother and the decision making that has to be made for him in the future. Would the power of me having the power of attorney be able to control that or not? Okay.
Brian, have you heard enough to answer that in a general sense?
Well, I'll probably be told if I haven't, but it seems to me that you're talking about two enduring powers of attorney, one by your dad and then one by your brother. Now, in view of what you described your brother's circumstance, it would be very desirable, if you can, for your brother to do an enduring power of attorney, obviously. So far as your father is concerned, if he's done an enduring power of attorney appointing both of you, then it's a matter for your father whether, in light of your brother's circumstances, he believes he should and is able to change his enduring power of attorney to exclude your brother if your brother's on the pathway to losing his capacity, for example. Because if you lose your capacity as someone's enduring power of attorney, you can't be their enduring power of attorney, even if you've been appointed. So it seems to me your father needs to think about that himself. That's his decision. as to whether he should change his enduring power of attorney. So far as your brother is concerned, he definitely needs to do an enduring power of attorney in his circumstances. And there's no reason why he can't appoint you, but it would be more common for him to appoint, for example, his spouse. But again, that's his decision if in fact he's able to make that decision.
Thank you so much, David, for your call on 1300 222 774. Let's go to Keith now, who's called through. Hello, Keith.
Yeah, good morning.
Good morning. What's your question?
My question is, my father's been in a nursing home for about 2 years now, nearly, and he owns a property that I run a business out of, and I've lived on that property for 23 years. And I want to know about will it have to be sold for his nursing home?
Go, Rachel.
How has he been paying for his aged care costs up until now?
I was classed as a protected person.
Right, and are you still living in the property?
Yeah, I live there and I run a business out of it.
So with the protected person rules, and just for those who don't know about the protected person exempts the home from assessment for aged care means testing. That can be a spouse or dependent child, a carer who's been living in the home for at least 2 years, or a close relative who's been living in the home for at least 5 years, and those last two must be eligible for an Australian income support payment. If you're a protected person and you're still living in the home will continue to be exempt while you live there. That's for aged care purposes. The thing you need to watch out for is the Centrelink exemption ending. So the Centrelink pension exemption doesn't have that definition of a protected person. So I think you need to have a chat to a financial advisor or have a chat to Centrelink about whether or not you can meet, I'm guessing this is a farm, whether or not you can meet what's known as the extended land use test and have the asset exempted under those rules.
Thank you so much, Keith. And just on the issue of paying a RAD and the difficulties, Rachel, of paying a RAD on behalf of your parents, there's a little trick here or a little trap. Do you want to elaborate on that?
Yeah, sure. So I guess, again, coming back to this pressure that people feel to pay that lump sum, and it can look like a big disincentive to not, because the daily payment is calculated at 8.3%, but it can lead to the kids passing the hat around to come up with that money. When you do that, the money that gets paid into the RAD is an assessable asset to your parent. So you can't offset it by the loan that you've all kind of chipped in for. The other thing to watch out for, so that will drive their means tested amount up. The other thing to watch out for is that the aged care facility, generally speaking, is not going to recognise that loan. So they're going to refund the RAD either to the resident when they leave or to their estate. You can't go back to the aged care home and say, I gave you $100,000 for mum's refundable accommodation deposit. I need you to pay that to me, because aged care facilities can find themselves in conflict with the estate. So you need to document that. If you are going to go down that road, because there's been plenty of estate fights where children say, no, my brother or my sister gave mum that money to pay her RAD and it was a gift, it wasn't a loan, and therefore is not entitled to get that money back from the estate.
Stephen has called through on 1300 222 774. Hello, Stephen.
Yeah, hi.
Hi, what's your question?
Well, it's to do with the executor of a will, actually. My wife is the executor of a late father's will, which involved a trust set up for one of his grandsons. And it's been going on, and the child is quite young, so it's going to go on for another 10 years. And it's obviously an arduous task. And she was inquiring whether she could actually give that back to, I don't know, the public trustee or give it to her brother to run. And what is the steps to do that? That was my question.
Brian.
Thank you for the question, Stephen. That is a good question because it's a common question. A lot of people don't realise when they accept positions like that it could take a very long time for the position to wind up. So she's in a position now where presumably she realises that it could go on for a very long time and it's quite arduous. She's talking about replacing herself with somebody else. Now, the answer to that question can lie firstly in the terms of the trust, which is set up in the will. So there would be a part of the will where there are words which set up the terms of the trust, which may include a provision about a change of the trustee or the executor that you refer to. If not, then it may require an application to the court by her to replace herself with, for example, the public trustee. It's not a case of simply walking out and closing the door. Because she's now formally appointed to this position, the law comes in and says, this is what you have to do to get out. So that means she has to go through either a legal process under the terms of the trust in the will, or apply to the court for the court to approve her stepping away and bringing in, for example, the public trustee. It's not easy.
Thank you very much, Stephen, for your call. Let's go to Dom now. Hello, Dom.
Good morning.
Good morning. What's your question?
A basic one. How do I go about getting an enduring power of attorney for Mum? She's 89. She doesn't speak English, and she's quite deaf. So what do I do?
Two options. One is you can DIY. In other words, you can go to a newsagent, or you can download from the relevant government website a copy of the document. Mind you, they're all different from state to state. I'm not sure where you're ringing from, but each state and territory has different forms, so you need to be careful about which state you're in. So you can download it and do it. In other words, complete it, and presumably in most cases you'll have to then take your mum before a JP or a lawyer to have her signature witnessed and attested to her capacity to understand what she's doing. That's the DIY approach. Now, given that your mum presumably doesn't speak English and presumably can't read English, is that right?
Yes.
Yes. What that requires is that the document would have to be effectively translated for her, and that would have to be done in the presence of a witness, in other words, a JP or a solicitor or a commissioner for declarations. So the document would have to involve a translator who would have to literally translate the document to her in order for her to be assessed as being capable of understanding it, not because she has any mental deficiencies, but because she simply can't understand the words. So the words have to be translated to her language, and then she has to be assessed as understanding both the words and the nature of the document by the witness, the JP. I would suggest you need to go and see a lawyer to do that process.
Thank you so much, Dom.
Thank you.
And let's go to Pete now. Good morning, Pete.
Morning, Lisa, and your guest, Brian. I really just wanted to agree with you, Brian, and reiterate, stating the obvious, that if you haven't had these conversations with your parents, or in my case, parent, it really doesn't get easier. Tomorrow never comes, and what I've found is that I first approached this subject about 10 years ago. Mum really didn't want to know about it, and constantly just wanted to sort of put it off because, I just don't feel up to it this week or at the moment because of whatever reason, and it really just doesn't get easier. And as Brian said, when you factor in frailty creep and also what you might call, I guess, mental frailty creep, all of a sudden the person you're trying to have these conversations with is really not the person you need to have the conversations with, because they've got all these extra issues to deal with, like frustration about
and it's funny, Pete, because you talk about the difficult conversations just have to happen, but actually it's one of those things where you think, yes, I'll get onto that when I can get onto that, and yet people do put it off. Rachel, you have a perspective here?
Yeah, I think it is a tough conversation. I think the art of the conversation is in having a with you rather than to you approach. The other thing to remember, and I think we've probably kind of confirmed this bit of an aged care myth, is that the overwhelming majority of people who receive aged care in this country are not living in what we used to call nursing homes or aged care facilities. The overwhelming majority of the 1.5 million people who received aged care in this country last year, only 200,000 lived in an aged care facility. So I think it's really important that you start these conversations early, have that with you rather than to you approach. And if they think it's a slippery slope to a nursing home, they will shut it down. But if it's really about how do we enable you to stay living as independently as possible for as long as possible, the conversation changes.
Brian, any perspective there?
Yes. The reality is that you need to start with a coalition of siblings. In other words, all of the children need to be on the same page at the same time in as Rachel says, discussing it with the parents and even the parents-in-law. Remember, there could be parents-in-law as well. So having all the siblings on the same page is very powerful when it comes to confronting and raising the issue, because the parent can see it's not just one particular child who's pushing this with some secret hidden agenda. It's all of them coming together and explaining to the parent why they are concerned and what they need to address, what may never happen but could happen. We call it family planning. Do you remember that, Lita? Family planning?
Family planning, yes, the family planning.
This is latter-day family planning.
And just speaking of siblings, Gary is here on 1300 222 774 and has a perspective. Hello, Gary.
Good morning. Thanks. Excellent talk this morning. Hey, look, I've been told if a sibling who is power of attorney is acting up a bit, carrying on a treat, that I've got one who's enacted her power before my mother has lost her reasoning, and basically was banned from the elderly home where my mother now is. And I've been told that as soon as mother goes into the power of attorney mode, that my sister's ability to be power of attorney could be challenged via VCAT, so the state trustees take over. Is that correct?
Well, there are a number of grounds you can challenge an enduring power of attorney. One is, firstly, it's not valid. In other words, it hasn't been properly completed. The second way you can challenge an enduring power of attorney is that the power of attorney or the attorney has no power. In other words, their power has not been triggered. So just doing an enduring power of attorney doesn't mean that the person you've appointed has the immediate right to exercise it. It depends, for example, on what the document says. If the document says, it normally does, that the attorney cannot exercise power for your mum in relation to her personal healthcare decision-making unless she's lost her capacity, then you can't exercise that power unless you can demonstrate that she has lost capacity. Now, the financial side is a bit more complex because in Queensland, for example, you can exercise an enduring power of attorney for financial matters for a mum immediately without having to prove that they've lost capacity, if that's what the document says. The third way you can challenge an enduring power of attorney is to say they're guilty of bad behaviour. In other words, they're not doing their job very well, or indeed, they're doing their job to ensconce their own wealth. In other words, they're using it to enrich themselves, and that's really common. It's called elder abuse. So there are three ways you can challenge an enduring power of attorney. But also, even if someone has an enduring power of attorney that's actually triggered, in other words, they can use it, they still have obligations. It's not a blank cheque. They still have obligations to ensure that they get the views of mum about decisions they're about to make, and even sometimes get the views of the siblings about what decisions are being taken. Now, that's a very good diplomatic thing to do as an enduring power of attorney, to keep the other people in the loop, even though they're not entitled to make decisions, but to keep them in the loop in terms of what decisions you're going to make. Because then they can say, we're included, there's no secret agenda here, it's all open and transparent and accountable. So it's all about doing it diplomatic. But if you have someone who is not doing it properly and is just hell-bent on enriching themselves, you've got those three options. And one option, which is to go to court or a tribunal and to have them sacked, is often used these days because a lot of people see their enduring power of attorney as a blank cheque, which is not.
Thank you for your call, Gary. Now, Nicola from Eltham, I think you might have dealt with this, Rachel, but you might want to go a little bit deeper. So can you talk about the RAD and what happens to it on the death of the elderly person? It is a minefield, especially if one child or current wife has put up the funds.
Yeah, that's a topic we haven't actually covered, but where you have elderly parents, but perhaps one is your natural parent and one is a second marriage or a third marriage, that's where it can get really interesting, because when you've got a couple and one person goes into aged care, they're actually assessed based on their joint assets and their joint income. They might run those assets and income completely separate from each other, and it's not uncommon that we see situations where the person going into aged care really doesn't have a lot, but Centrelink are assessing them as having half of their spouse's wealth and saying, well, you need to pay a RAD because you've got all this money. That can lead to some very interesting outcomes where the spouse is then loaning money, or if they're perhaps not that well advised, giving money to that spouse, and then that, like I said before, it comes back to the estate, not to the person who's paid the money. So you need to be really, really careful around the payment of the RAD. But when it comes to the actual RAD itself, it's held by the aged care facility. There's rules around what they can invest in. It's guaranteed by the government. It's generally refunded very quickly after the resident leaves or passes away. You just show a letter of administration or a letter of probate.
Thank you, Rachel, and thank you so much for your question, Nicola. Brian, before you go, what is your one big tip for people listening and thinking, oh, I really should get onto this?
Think of the days when you were family planning and bring them back alive. In other words, start it now to plan your family. Your plan extends to your parents, your ageing parents and your ageing parents-in-law, and your siblings. Start talking. Have an agenda. We actually use an agenda for family planning meetings in our practice. So the reality is the family can gather together with an agenda which covers all sorts of interesting things about the future, such as let's talk about mums and dads' health and capacity, their family dynamics, the lifestyle options, finances, the legals. So we cover this broad range of family planning, which both informs them in terms of what issues they will need to address and also can have the effect of empowering the parents to do something. Because gathering like that in a sort of semi-formal facilitation session is really helpful for motivating people. So my recommendation, my mantra is family plan.
Family plan. Thank you so much, Brian Hurd. Brian Hurd is a lawyer specialising in elders law, and Rachel Lane, thank you.
You're welcome.
She's our financial specialist from Aged Care Gurus.